Jury victory in Hamilton County. This guy called us in 2019. Old case. Took forever to get to trial because COVID delays, shutdowns, all the other fun stuff. But we finally went to trial. But Matt, before we start talking about the trial, walk us up to all the things that took to get us to trial.
Yeah, so like you said, he hired us back in 2019. So this case has been going on for a while. When he first contacted us, he goes, hey, this event never happened. So he kind of put us right into a story, and then he locked us in. Hey, this never happened. I cannot, in any circumstance, be a felon. So what do? We go to court. We say, hey, we negotiate with the prosecutor. We try to figure out, hey, what can we do to try and not make this a felony? Prosecutor didn't want to budge, so at that point we knew we were going to go to trial.
And so just back up 1 second. This gentleman was charged with causing injury in a work zone. He was charged with criminal recklessness using his vehicle as a deadly weapon because he allegedly struck this highway worker. And then for good measure, they threw in leaving the scene of an accident. And when the police came, our client talked to the officers. He didn't try to hide anything. They called him back to his house. He came right home. Officers, what you need to know. We don't encourage anyone talking to the police, but this guy just said, hey, I'm not hiding anything. And he told the officers that day, none of that happened. And so, like Matt said, he already said it didn't happen. Our client also told us it didn't happen. And so...
well, the officers even put in their report, hey, this is leaving the scene, causing accident, or leaving the scene of an accident. So originally, the cops thought this was a misdemeanor up front. Circumstances changed, whether it was the alleged victim gets involved or he starts throwing a coup or anything like that, and all of a sudden the charges go up. Now, the prosecutor has the authority to do that. This goes in originally as a misdemeanor, and then all of a sudden we get these trumped up felony charges, which literally would have wrecked our client's life. Literally would have wrecked it. So at that point, we knew it was misdemeanor or trial.
And so our client originally hired a different lawyer, and the lawyer saw a misdemeanor. Oh, not a big deal, I'll take care of it. Then, just like Matt said, they piled on 2 felony charges, and I give the attorney so much credit for realizing she was in over her head. She called her friend, Marc Lopez and Matt Kroes, and we hopped in, and just like Matt said, we can't have you a felon. And Matt, walking us, our client had no history, never been in trouble before. So our client was like, well, hey, I've never been in trouble before. You guys should have no problem getting this case dismissed. Matt, was it that easy? Hey, dismiss this case?
I've never had that circumstance ever play out where a prosecutor waves a white flag, we're just going to dismiss the case. I've never seen that happen in my career. Now, originally what happened was, hey, the alleged victim's really involved in this case. He really wants your client to go to jail. He really wants to be stuck a felon, which were the 2 main sticking points. I don't want to go to jail, and I do not want to be a felon. Those are 2 things that are going to ruin my career. Absolutely. Well, Indiana, because of the Victim Rights Act, victims have a say in any type of an agreement that a prosecutor can extend. They can either agree with, they can deny it. Now, a prosecutor can still offer a plea that they believe is appropriate. But in this instance, they believe that jail time and a felony was appropriate. Now, they gave us a couple of options.
And just real quickly, the alleged victim, who a jury decided he wasn't believable, so we keep saying alleged victim, but he's not really a victim. He wrote some of the longest letters I have ever seen to the prosecutor. Just long letters. He needs to spend a year in jail. He needs to go to jail for years, plural. When I was in trouble in the past, I paid my time. He should have to do this. I want him to be a felon. I mean, like Matt said, prosecutors have to take consideration of the victim's desires and wants. But, prosecutors are human beings too. If you have a guy causing a scene, I want jail, I'm going to go to the supervisor, calling phone calls, there's only so much a prosecutor can do because they ultimately have to watch out for their careers too.
Of course.
Because that's a quick way to get fired as a prosecutor, is just don't listen to the victims or just roll over when you have someone being very vocal. So even though, you can talk about the pleas always just were terrible. I wouldn't even call them pleas. And I kind of felt like the prosecutor's hands were tied. But Matt, walk us through these negotiations.
So originally we go, and our 2 big stopping points. No jail, no felony. Originally, prosecutor came to us, he can do cap of 30 real days in jail. or cap at 30 days in jail, which means he probably would have done a couple of weeks, assuming he didn't get any fights, and then he would have done some probation, and then after that, he would have been able to petition the court, assuming there were no violations, to make it a misdemeanor. So automatically right there, he's looking at jail time, and he's a convicted felon for X amount of time.
At least a year.
Correct.
And he'd be on probation for that year, and so for that year, he would have to say, I'm a felon. Hey, what's going on? Hey, I'm a felon. Hey, I want to volunteer at my kid's school. Oh, you can't because you're a felon. Hey, I want to come onto the school property. Oh, sorry, you can't because you're a felon.
That was a huge thing for him, too.
Yeah, even his job was like, try to get rid of this because if you're a felon, we got to relook at your employment options. I mean, so the felony was just huge.
Correct. But then when we conveyed that to the prosecutor, he goes, again, I agree, his hands were tied, I think, by the victim, alleged victim in this case, whatever you want to call him. So the second offer was, hey, your guy can take the 30 days in jail. He's going to get it, period. He's going to jail, period. You can't argue. But we'll make it a misdemeanor right away. Well, that posed another problem. Well, if he's going to get jail time and he's going to spend that time in jail, he loses his job. So again, that was a non-starter. So at that point, I sat down with him. You sat down with him. We roundtabled this, and we just decided there's no other option. We have to do a trial here.
That's true. And so the day before Thanksgiving, I spent all afternoon with this client recreating the scene, using his wife as the driver. He was videotaping. We spent all afternoon. And I give this client so much credit because his neighbors are driving by, honking and waving at us, and I could tell it was uncomfortable for them. But the only chance I knew of winning this case was presenting a very tight story to the jury, a story that not only my client and his wife and witnesses believe, that I also believe because I saw how it occurred. So Matt was involved in every step of the way. I remember all my family was home for Thanksgiving. We had 15 Lopez's at my house, and I wasn't there. Every 5 minutes, my wife was texting me, "Where are you at? This is ridiculous." But everything paid out, Matt.
Oh, it was great.
Walk us to the actual trial.
So, I mean, we started trial. We knew it was going to probably be one day. It did turn out to be one day. After we got through opening statements, after we got through, jury selection, we realized something. Going into the trial, we had 3 different stories. We had our client, never happened. Guy flopped, never hit him, didn't happen, period. We had an eyewitness who's a distance away, can't see anything inside the vehicle, but she's sitting there saying, oh my gosh, your client and the guy that allegedly got hit, that didn't get hit, apparently the jury found out, they're waving their hands, they're yelling at each other. He gets smacked by the car and he rolls up underneath the car. Then you got this other guy, the alleged victim.
I'm smiling because this is the stuff that we dream about as defense attorneys, multiple versions of events. Keep going, though.
Then you got the alleged victim over there saying, he hit me and he struck me so hard, I flew 12 feet in the air doing somersaults and I land on the asphalt. Officers arrive on scene, ambulance arrive on scene. There's no visible damage to this person who flew 12 feet in the air. In fact, the only damage they could see was maybe a scrape in his blue jeans. Now, he's a construction worker with a scrape in his blue jeans.
I saw those pictures. I thought they were just stonewashed, but hey, that's me.
So, once we start calling the witnesses, they call this guy. And he gets up and he testifies. He tells a 4th story. So at this point, I'm going insane in my mind. I can't even, I know you were too, but we've got now 4 versions of events from a very short time frame. It was wild. So by the time we get to the end of this, jury goes out and deliberates. They couldn't have been out for 25 minutes. They come back, not guilty across the board. It was the 3 greatest verdicts ever. Because the greatest 2 words, not guilty. So great, it's my license plate. Now, we got not guilty, and one more for good measure, not guilty.
Oh, absolutely amazing. Our client was the most, even before the verdict was read, he took me and Matt to the side and he's like, what you guys did was absolutely amazing in there. And I appreciate it. No matter what the verdict is, you guys tried your guts out. And I love hearing that. Him telling us that beforehand meant the absolute world. And it couldn't happen to a better person. He has an amazing family support system. All of his neighbors say he's just a great guy. And, man.
I was really happy for him. I mean, it couldn't have happened to a more deserving, or at least the verdict, I guess, couldn't have been for a more deserving person.
Absolutely. It's a huge victory for our client. Matt, excellent work.
Dude,
Super
it was fun,
proud,
man.
Absolutely fun. Great being in a courtroom. There's not been as many juries the past 2 years just because of the situation we're all living in, but there still are juries. And still justice is often found at the courthouse. even in 2022. If you have any questions, give us a call, 317-632-3642. Remember, always plead the fifth.